Hello everyone, this is Tom Fox and I'd like to welcome you to episode 267 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across four key areas. These four areas are sales and sales channels, including distributors, resellers, and partners. Number two, suppliers. Number three, customers. And finally, human capital, which of course includes employees and contractors. You can find out more information on the Red Flag Group at www.redflaggroup.com. If you're listening to this before 10 a.m. on Central Standard Time on July 14th, check out the Red Flag Group webinar on supply chain risk management. It's going to be the first in the series, and I'm helping put on. It'll be very interesting around wrapping up your risk management program for your supply chain. I hope you will check it out. Today, I have a real treat for you. I have Mike Kelly. Mike is a partner at Hogan Lovells in Washington, D.C., and he's written a very interesting article, which is really a client alert entitled, "What is Driving the Justice Department's Pilot Program on FCPA Disclosures?" And Mike and I take a kind of a deep dive into the pilot program, what led the DOJ to create it, and what companies might expect from it going forward. The episode comes in at just around 20 minutes. This is Tom Fox. Thank you very much for listening to the FCPA Compliance and Ethics Report. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, you are in for a real treat because we've got Michael Kelly, a partner at Hogan Lovells in Washington, a noted white-collar practitioner and expert, and also a very interesting thought leader in the legal component of FCPA compliance. And Mike and his associate, I guess, Christina Murphy, wrote, I'm not sure if it's a client alert or a memo, but it really caught my eye. And I asked him if he could come on the podcast and talk about it. So, Mike, with that somewhat long-winded introduction, welcome and thanks very much for taking the time to visit with me.
Well, good afternoon, and thanks for having me on.
So this, is it a client alert, or what would you call this document?
Well, it's kind of multifaceted. It is both a client alert, and it will be the subject of an article in the International Law Office, which is coming out on Monday.
Okay, well, it's entitled, "What is Driving the Justice Department's Pilot Program on FCPA Disclosures?" And as much as I'd love to get into your ultimate paragraph, maybe we ought to set it up with you kind of describing what you think the DOJ's goals are, or at least that there was a dynamic tension between two goals which may have led to the pilot program.
Sure. I think the DOJ has struggled with these two very different goals for some time now. On one hand, they want companies to come in and voluntarily self-disclose. It helps bring them cases. It helps them maximize the effectiveness of their enforcement actions. But at the same time, they don't want to give away the farm, and they want to make sure that they retain their prosecutorial discretion. You know, the easiest way to get companies to self-disclose would be to say, you're getting a declination if you self-disclose, and they clearly don't want to go that far. So this is an issue they've wrestled with for some time. The problem they've had recently is more and more companies have questioned the value of cooperation and have questioned whether it still makes sense to come in a way that they may not have questioned as much in years gone by.
And would you say that the questioning or that companies have been engaging in is due to one or more factors, which might be the cost of an investigation, the uncertainty and the result, or something else?
I think it's all of those factors. I mean, I think, there's been a long concern about, look, if I go in and disclose one thing, am I going to end up investigating the world? And DOJ has tried to respond to that by saying, well, look, you don't have to boil the ocean. But I think a lot of companies worry that, look, I make that first call, I don't know necessarily what I'm in for, and then I also don't know what I'm going to get at the end of the line. And that concern, I think, has been heightened by things like the Yates Memorandum, where companies say, well, look, they may think I'm not cooperating even if I do call them. So what kind of certainty can I get around this process? And I think that's one of the things that's really been driving this.
So the dreaded "where else" question is one of my favorites. But let me kind of take us back to the Yates memo, because Mike, I've been trying to draw a line from the Yates memo to the pilot program, And I had originally thought it was a straight line, but after reading your piece, I'm thinking that, or considering that perhaps it's a little more of a crooked line, and that the pilot program may be partly in response to the Yates memo. Do you see it that way, or is something else going on?
Well, I think there's definitely a connection between the two. I don't think either one sort of came out of the blue. Both were in response to very certain events that had happened.
Right.
I think with the Yates memo, the biggest event that's responding to is all of the criticism that DOJ got following the financial crisis about why aren't you prosecuting individuals, which caused DOJ to go back and say, well, look, is there more that we could be doing? Which I think has led to the conversations that then, spawned the Yates memo. Whereas the FCPA pilot program is a very similar issue, but it's a little bit different in the sense that companies have said, I think they're responding to a lot of the feedback they've gotten from companies in all these conferences that DOJ attends, where companies kept expressing these concerns about, why should I come in and voluntarily self-disclose, and that in itself would be of a concern to the Justice Department.
So you indicate that or at least it seems like you really believe the DOJ was telegraphing these concerns in speeches that they were making. You particularly cite to Assistant Attorney General Leslie Caldwell talking about the concerns of companies, more transparency around enforcement actions, and then the one point of, I don't know if certainty is the right word, but at least putting some structure around what companies could expect in terms of a reduction below the minimum of the sentencing guidelines. Did you kind of, I hate to say reading the tea leaves, but did you see those concepts articulated by DOJ officials on the speaking circuit?
We have seen them articulated by them on the speaking circuit, and it's one thing that they've also said in cases too. I think they want to dispel the notion that this is some mysterious process, and they want to say, look, it's pretty clear what our expectations are. And I think the pilot program is just one more articulation of this is what we want from you.
One of the things that I had noticed starting in 2014 that I really scratched my head around was the credit that DOJ was giving below the minimum suggested by the sentencing guidelines for companies that engaged in what I thought was pretty egregious conduct. So, for instance, we had Parker Drilling, which had C-suite involvement in the bribery scheme. They got a 30% discount below the bottom end. We had Hewlett Packard, who had multiple bribery schemes across multiple countries with, at least in my opinion, a complete failure of internal controls around compliance, and they received a discount of 25% below the minimum of the suggested low end of the sentencing guidelines. And then I heard a speech by Pat Stokes, the former head of the FCPA unit, last November at the ACI conference, where he talked about the credit that was given. And then when I saw the pilot program come out, I began to see really the DOJ putting that down in writing. Did you see any of that, or was that not something that was on your radar?
Well, I think the pilot program is really their first attempt to put kind of a structure in place in writing. But that, I think had kind of informally existed before, and if you sort of very carefully tracked all the enforcement actions, you could get a sense, although, as you say, in individual cases, you may raise questions about how is that really consistent with other cases. But I think this is something they've been moving to as the FCPA enforcement program is getting more mature, is they're trying to provide, certainty is not the right word because they're never going to promise you any specific outcome. But they're trying to provide more of a framework so that there's less surprise. And I think one of the big things that the pilot program really does is it really gives a roadmap to companies about, if you come in, this is what we expect of you, and this is what, the standards that we expect you to meet. And as part of that, they've articulated some numbers that are kind of the maximum discount that you can expect. I don't think it's that different. I don't think it's a sea change from what they were actually giving out before.
So the numbers you're talking about are the potential 50% reduction in the fines off the bottom end of the sentencing guidelines if there's self-disclosure, full cooperation, extensive remediation, and profit disgorgement, up to 25% if there's not self-disclosure or something less than full cooperation. Do you find that in your practice to be meaningful or material for a client or a company that's faced with this decision?
I think it's helpful for them to see what generally they can expect, but I think what you always have to caution clients about is those are not hard and fast numbers, and so much depends on the facts. And the facts the facts are always so different that you can always try to find some distinction. So, it's a guidepost, but it's not a promise. And I think that's the thing that clients most need to know.
I really like that, a guidepost but not a promise. Well, how about the following? Does this change the discussions and/or decisions that corporations and boards have to make around self-disclosure, or is it simply just another data point they should consider?
I think it's more of a data point that they should consider. I think the most helpful thing is, for a company to take this before an investigation starts and look at what DOJ expects, and then honestly ask yourself, are we actually meeting the guidelines they have here? Because the problem you have in a lot of investigations is if you haven't done that before the investigation starts, then you may be out of luck before you even realize that you're in the middle of an investigation. And I think that's probably the greatest value. Once you're actually in discussions with DOJ, then you can argue about this, but there's always a way that someone can say, well, these facts are slightly different, and we have to take this other fact into consideration. If you look at the first 7 pages of the memo are talking about all the ways in which you can fail to meet the standards, and you can fail to get the cooperation credit. So you always have to be very mindful of that.
So your memo or client alert really doesn't touch on it, but one of the things that was going on during the timing of the Yates memo and up through the pilot program was the creation of a compliance counsel position in the DOJ and the filling of that position. Do you see that compliance counsel in the person of Wei Chin as impacting any of these concepts around the pilot program, or is that really separate and apart in your mind?
I think they go together. I think Wei Chen, who by all accounts is an excellent lawyer, I think is a really valuable addition to the fraud section because she has the frontline experience at Microsoft and Standard Chartered and Pfizer. She can help give a very realistic assessment of the challenges that compliance officers face on the front line, which I think will help both DOJ, and I think it also help companies to have a more realistic and transparent conversation in terms of what's happening.
So since the pilot program has been announced, we've had 4 enforcement actions, and I'd like to focus your attention on 3 of them, Akame, Nortec, and Analogic. And on the first 2, a couple of significant or unusual data points were that the companies self-disclosed prior to the completion of the investigation, and we had a relatively quick turnaround from self-disclosure to resolution, less than 18 months. Do you find that as a model that the DOJ is going to try to use going forward, or were these just anomalies that just happened to pop up?
Well, I think it's very fact-dependent. The one thing about both Nortec and Akame is you're talking about a really discrete number of employees at issue. I think in Nortec you're talking about 5 employees, and the total amount at issue I think was about $300,000. That's what Nortec paid in disgorgement. Akame, you're again talking, I think, about there was 1 employee who was fired, and there were 5 others who were disciplined for not catching the conduct, and you're talking about $650,000 in disgorgement. So these are the kind of really discrete investigations that shouldn't take as long to wrap up than if you have a much larger investigation involving more employees, which you would expect to take longer.
So one of the things that I've seen in the commentariat since these is that it's been called a kind of a publicity program by the Department of Justice around the pilot program, and really trying to utilize these 4 cases to show the benefits. I can't say that language persuades me, but I do see that there are things to be learned and gained from these, particularly around what these companies did to obtain the results they did, or were the fact patterns so unique that you don't think that other companies can draw from them?
Well, I think it's going to depend on the extent of the misconduct, because even the pilot program toward the end, they say, well, look, there are a lot of factors that we can take into consideration, including how high up in the company the misconduct went. If Nortec and Akame were relatively discrete matters without high-level involvement. I think both involved the China subs for both.
Right.
You know, that's not, you can wrap that up much quicker, and that's a very specific kind of case. I think the question for a lot of companies are, when we start digging, are we going to have a Nortec and a Kamei case, or is it going to be turned into something much larger? In which case you're looking at a potentially different kind of disposition.
So I was really intrigued by your ultimate paragraph, where at least one of the key points I got out of it was that the department was trying to maintain really ultimate flexibility, even while laying out some parameters that companies could consider. Is that a fair assessment of at least your paragraph, or what your thoughts are on this?
Absolutely. I think that is a fight that they have been fighting for a long time now. I think they don't want to, either buy a pig in a poke, or they don't think they want to tie themselves in knots by making promises that, somebody comes and voluntarily discloses, and then they discover that it's some really bad conduct, and they want to take more action than just giving a declination. The question for me is, how far is the DOJ going to go to promote the pilot program? Are they going to penalize some companies that don't meet that standard as a way of really making clear that there's, this set of cases over here, and then if you fall in the other camp, you're going to get treated much worse? I mean, things that you hope for from DOJ is that they'll treat each company fairly based on their own facts, but the thing that you worry about a little bit is that there could be an incentive for DOJ to say, well, look, we're going to make it really clear that if you voluntarily self-disclose, you're going to get treated much better than if, for whatever reason, you don't happen to find the issue in time and we find out about it first.
Well, I had thought that was the import from the Yates memo, but after the pilot program, I wasn't sure if it was that strong. You really feel like it's the key component is the self-disclosure?
I think if you don't have the self-disclosure, I think you may not be as likely to get declination. I think you're probably more likely looking at a non-prosecution or deferred prosecution if you do everything right. The question is, if the self-disclosure doesn't happen, are we going to see declinations or not? And I think that's a question that really hasn't been answered yet.
Right. Well, Mike, this has been really fascinating. You did announce that you're coming out with a more full version of this paper, so I was wondering if you might be able to tell the listeners where that will be published and when.
Sure. The American Criminal Law Review, which is a law review put out by Georgetown University, we're publishing a paper describing really two powerful trends that are happening today in federal criminal law enforcement. The first of which is obviously the Yates memo and the increased drive to increase the number of individual prosecutions in the United States. And the second trend, which I think is equally powerful, is concerns by the federal judiciary that maybe we've gone too far in interpreting some of these federal statutes. And I think you've seen cases beginning with the Skilling case in 2010, but all the way up into the case of Governor McDonnell last month, where the Supreme Court has said, we think the government is interpreting some of these really broad federal statutes too far. And the real question will be, when these two trends collide, is it going to change the law enforcement environment, and how should the courts, how should the Department of Justice, and how should companies and defense counsel react when all this comes together? So that should be published at the end of this month, at the early part of next month.
Well, that debate has been going on for some time, but you really lay out in your article, kind of lay out the cases and kind of how we got to where we are. And in the FCPA context, of course, we get very few, if almost no cases go to trial. So we really don't have that sort of judicial oversight. But I agree with the Supreme Court's ruling in McDonald. I think they are almost inviting the lower federal courts to take a look at the prosecutorial discretionary calls that are being made.
Right. And if you have a lot more individuals who are going to trial because the Department of Justice is getting Yates binders, or however they want to refer to them, I think you're more likely to see that kind of judicial skepticism turn to the FCPA in a way that maybe hasn't taken place in the past.
Well, after your paper is published, I hope I can get you back because I definitely want my listeners to not only read your paper, but hear you talk about it because you really lay out some very interesting trends and kind of portend where it may all go, as well as anyone I've seen lay it out.
Well, absolutely. Well, I look forward to that. I appreciate that.
And finally, if anyone wanted to follow up with you directly, could they email you? And if so, how might they do it?
Absolutely. Best way to reach me is my email, which is michael.kelly, with just one E, Kelly, at Hogan Lovells, HOGANLOVELLS.com.
Well, Mike, thank you very much. I look forward to continuing the conversation.
Appreciate it, Tom. Thank you.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have two requests of you, if I could. The first is if you like this podcast and you're listening on iTunes, please rate this podcast on iTunes. I would greatly appreciate it. And if you have any comments, you can leave them on my website, www.fcpacompliancereport.com. Also, I'm developing a list of questions for my next mailbag episode. So if you have any questions, I hope that you would email them to me and I would discuss them at a later podcast. You can email me at tfox@tfoxlaw.com. This is Tom Fox. I'd like to thank you very much for listening, and I look forward to visiting with you again.